Hi, I'm Chuck Colson with this week's 2-Minute Warning. As soon as the President announced his nomination of Solicitor General Elena Kagan to the Supreme Court, both sides started mobilizing their forces. Hearings ought to begin by the end of this month. As someone who's followed the court and the nomination process for years, I'm looking forward to hearing what, if anything, Kagan has to say. There are questions she must answer. At the same time, I'm not expecting much from what has become a kind of theater. This may surprise you, but barring the completely unforeseen, I think Kagan will and should be confirmed. She's not the kind of lawyer I would nominate, but that's not the issue. I would disagree with her on many legal questions. The Constitution is clear, however, that the President makes the appointment and the Senate gives its advice and consent. The Federalist Papers make it very clear that advice and consent means vetting the nominee for things like moral problems, cronyism, or nepotism. There isn't the slightest suggestion in the constitutional debate that the Senate ought to have an equal say on the merits of a nomination. This is the President's appointment, and I've made this argument when there were Republican presidents in office. I'll make it when Democrats are in office as well. The problem is that all this wrangling over the roles of the President and the Senate ignore the more crucial issue of the role of judges and the nature of law. That's what ought to be debated. For centuries, the law was considered a stable body of statutes and opinions. It was the accumulated wisdom of centuries of legal reflection and case law. In this view, the role of a judge was to decide cases in accordance with that accumulated wisdom. Then came the famous American jurist, Oliver Wendell Holmes, who proposed a new way of looking at the law, one that severed the relationship between the law and morality. Law was no longer something objective based on time-honored ideas about what was true, but instead it became a matter of judges deciding what to do in a given situation that owed more to sociology and even economics than to Anglo-American legal tradition. Thus it is, as Robbie George of Princeton writes, abandoning the idea of law as an objective standard resulted in judges feeling free to legislate from the bench, which they continue to do today. This is true of Democratic appointees and Republican ones as well. To paraphrase my old boss, Richard Nixon, we're all judicial activists now. Losing the legislature? No, file a federal suit the next day. Unsatisfied with the pace of progress? Find a judge who'll help you speed things up. This dramatic change in our philosophy of the law threatens the very rule of law itself. And this is what we ought to be talking about at the confirmation hearings. Do we want judges who will interpret and be bound by the great body of law we inherited from our forebears? Or do we want judges who make up the law as they go along? As Christians, we must be able to make the case that law is founded on moral, time-honored principles, what lawyers call stare decisis, and must not be manipulated by judges who feel free to make political or emotional or sociological decisions. If we don't, we'll continue to see the courts act arbitrarily and arrogantly, trampling the right of the people to self-government. Robbie George has written a brilliant but very scholarly piece on this subject, which you can read right here at the Colson Center. It's for those interested in the philosophy of law in a serious way. But you can also download a chapter from my book, How Now Shall We Live, in which I discuss what has happened to the law in our postmodern era. My chapter is very accessible for Christian laypeople, and you can download that free as well. The rule of law, that's the true issue. I'm Chuck Colson, and that's this week's 2-Minute Warning.